The next matter to come before us this morning is in re RR. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you are the appellant and wish to reserve that time, if you let me know I'm keeping the clock this morning, and I will keep you apprised of the passage of time. We've read the briefs and we are ready to proceed when you are.
Thank you, Your Honor. May it please the Court. Neil Ironwall on behalf of the appellant Leslie Hosfield. I'll reserve 3 minutes for rebuttal. May it please the Court. Your Honor, the facts of this case are not really in any dispute. There was a filing by Children's Services that my client's child, he's the father, was abused, dependent, and neglected. There was an adjudicatory hearing before the magistrate who made a finding of dependency only, dismissed the allegations of neglect and abuse. CSB filed objections claiming that believes that the magistrate erred and there should have also been findings of neglect and abuse. Father filed cross objections saying the magistrate made no findings of reasonable efforts from the adjudicatory hearing. We held a dispositional hearing while those objections were pending, and the magistrate awarded my client, the father, temporary custody at the dispositional hearing. The child was in the agency's temporary custody at that time. The agency immediately filed objections to the dispositional hearing, which under Juvenile Rule 40 imposes an automatic stay. So they went and grabbed the child from the father at the time they filed their stay, and then both parties filed supplemental objections once the transcripts were in. Again, the agency filed supplemental objections saying, based upon the evidence at the adjudicatory hearing, that neglect and abuse should have been found. Father also filed cross supplemental saying magistrate made no proper findings of reasonable efforts at the adjudicatory hearing, that the case plan was defective. Then, while the objections were pending, father, myself, the counsel for father, filed a motion to lift the automatic stay and have the child be returned to the father while the objections were still being considered by the judge. The judge set a hearing, and you'll see this in the record, set a hearing on father's motion to lift the automatic stay pending objections. So we went for a hearing that went over 2 days before the judge, where I argued that the stay should be lifted and the child, as found by the magistrate, should be returned back to my client, the father. The agency said, well, there is post-dispositional evidence that we want the court to consider in lifting the automatic stay. They started bringing the caseworker, and I objected, Your Honor, we're not here for objections. And the judge said, I am only considering this testimony for lifting the automatic stay. So I said, okay, fine. We're only here on the automatic stay. That was the purpose of the hearing, and the evidence is only to be considered for that purpose. No problem. So then the caseworker testified why things after the dispositional hearing the child should remain in temporary custody. And then the judge issued a ruling like a month later after the hearing saying we came for a hearing on the objections. And based upon that hearing, I am overruling the agency in part, finding the dependency was proper. I don't find evidence of neglect and abuse. However, for dispositional purposes, I think the child should remain in temporary custody based upon evidence presented by CSB at that hearing. Now, the father has appealed that decision on a few grounds. One is, when the judge issued her ruling, she in no way, shape, or manner discussed father's cross objections. We objected to the case plan, we objected to defects in the case plan, and that there was no reasonable efforts made at the adjudicatory hearing or at the time or at the dispositional ruling. And I cited case law from this court that says unless a judge explicitly rules on the objections, it's not a final appealable order. So I know the state has presented its own case from the court here that says basically the opposite. So I think the court here at the ninth is a little bit in flux on if a judge does not explicitly rule on all the objections, is it a final appealable order? And I will take whatever the court says, but to protect my client, we appeal. Now, the court says it is a final appealable order, fine, we'll move on to assignment error number 2. The second assignment of error is father was given, but his due process rights were violated because he was given no notice, none, either before the hearing or at the hearing held by the judge, that we would be here for a hearing on the objections, and everything related to the objections would be fair game to be considered. Again, the hearing notice, and you'll see this in the record, says it is to deal with father's motion to lift the automatic stay. And during the hearing, the judge said, we are only here on father's motion to lift the automatic stay. So there are other things we would have objected to if this was a hearing on the objection. I would have subpoenaed witnesses. It would have been like a full-blown trial on the objections. But since the judge said, we're only here to lift the stay, we didn't, we just took the testimony as is for that limited purposes. Because we figured, even if we lose the motion to lift the automatic stay, they filed no opposition to the dispositional ruling giving my client temporary custody. So and you'll see this in the transcript, I said we will win the objections even if you find there was abuse, neglect by CSB. They didn't cross-object to giving the child back to my client, the father, at the dispositional ruling. So we should win when the court eventually rules on the objections. Well, and unbeknownst to all of us, she said that hearing was a hearing on those objections. And based upon that, father, I'm going to keep the child in temporary custody. Now, we have a right to notice of that hearing and the purpose of that hearing and to be prepared for that hearing. And in the Forrester versus Young, a very similar case, that was out of a domestic court case, where the magistrate in domestic considered child support. And he said, I had no knowledge, I didn't know we were going to be discussing this. And this court reversed, saying that is a violation of his due process. You don't give him fair notice the purpose of that hearing, and he could not or should not or had no ability to know what was the purpose of that hearing, you cannot consider matters that are not set before the court. So if we are only there for the lifting of the automatic stay, we are not there to rule on the objections or present testimony for the objections. And for that, we believe my client's right to due process was violated. I couldn't ask for a continuance, I couldn't subpoena witnesses, because the nature of that hearing was unknown to my client and to myself. And
what happened at the end of the hearing, after the conclusion of the hearing, you're saying that the trial court, let me back up, beginning of the hearing, the trial court said, this is what we're going to consider, and you raised some concern, and the trial court said, you need not worry because I'm only going to consider this for on the issue of lifting the automatic stay.
Correct.
Was that the status at the end of the hearing?
Yes, as far as I knew.
So the trial court did not, we won't find on the record that the trial court said at that time, well, now that I've heard the evidence, I do think that this goes to the issue of objections. There's nothing like that.
There's nothing like that in your honor. And again, right, because the whole hearing was just to lift the automatic stay. So all evidence and testimony was presented on that limited issue. And I said throughout the hearing, they're not objecting to my client getting temporary custody from the dispositional ruling, so we will win that because they're not filed a cross objection. So that's correct, Your Honor. When we go through the transcript, there's nothing where the judge in any way, shape, or form stated, well, after considering it, I am now going to consider for the objections. And then finally, for the last assignment of error, Your Honor, when there is an adjudicatory hearing, the magistrate must make a finding of reasonable efforts. Here, the magistrate did make a finding that says, I find CSB engaged in reasonable efforts. And that's the extent of it. When the judge signed the entry adopting that, she did not mention reasonable efforts in any way, shape, or form. We have objected to that immediately after that hearing. We raised it again in our supplemental objection, and we raised it here in our third assignment of error. When there's an adjudicatory hearing, there must not only be a finding of reasonable efforts, but what were those reasonable efforts? A blanket statement saying we find reasonable efforts does not cut it. And I say case law, not directly from this court, but persuasive, where that exact same language was held as improper. There, and it was a court case out of the, I think it was the 12th, if I remember correctly, and in there the court said, Well, what the magistrate found there is that Claremont County Children Protective Services made reasonable efforts to prevent removal or eliminate the continued removal and to reunify the child pursuant to Revised Code 2151.419A1. This conclusory statement by the trial court is insufficient to fulfill a statutory obligation to make reasonable efforts determination. Rather, the law requires the court to briefly describe the relevant services provided by the agency and why they were not effective in restoring JN to his home. So here, the magistrate made that conclusory statement, which was not adopted by the judge. When we had the dispositional hearing, the magistrate gave my client temporary custody, so he did not need to make reasonable efforts findings, and we're not claiming he had to. And when the judge adopted it, there's nothing about reasonable efforts. However, when the judge then took the child, ruled on the objections, and took the child back from my client and properly placed the child with Children's Services, that was a dispositional ruling, and she had to make reasonable efforts at that finding. So you have to make reasonable efforts at both the adjudicatory hearing and any dispositional hearing, especially when there's a change in placement or custody. Here, the judge just said, I'm going to, I believe based upon the evidence at this hearing, that the agency substantiated why the child should not go back to the father, and I'm going to place the child in the temporary custody. She didn't in any way mention, shape, or discuss reasonable efforts. And again, the statute specifically requires you must do it both at the adjudicatory hearing and at the dispositional hearing. So if there's no further questions, I'll reserve the balance of my time. Thank you.
May it please the court, Heather DiMartino on behalf of Summit County Children's Services, the appellee in this matter. We are asking that this court affirm the decision of the juvenile court below. With regard to the first assignment of error, the agency does not agree exactly with the way the matter proceeded procedurally as described by appellant. I was not trial counsel. I will stand by the way I read the record, and obviously whatever the court finds is the actual procedural history. I think that will be what I would respectfully agree with. But while the objections were pending, based on the issues with the adjudication of just one of the three findings, so there was objections by CSB and then the cross objections at that time, there was a dispositional hearing, the child was placed with the father. There was no issue with that at the time. However, 8 days later, father was intoxicated to the point that he was passed out in bed with the child, blacked out, and then the agency, of course, no longer agreed with that child being in the father's care since he was intoxicated, no longer able to care for the child. So that was the issue. It's not a matter of, we were not objecting to disposition with the father. We were once he became intoxicated. We initially were not objecting to that placement, but once father was no longer suitable, then that becomes an issue.
But the question, I think, becomes when father shows up at the hearing and the notice has gone out that the hearing is going to be on one issue, is it a violation of his due process rights for the court to allow testimony on other issues on which he was not put on notice?
With all due respect, I believe that it is all intertwined. His argument is you should lift the stay and return the child to me. And the agency is saying, we can't do that right now, Your Honor, and here's why. Father was found intoxicated. Father knew that he was intoxicated 8 days after temporary custody was returned to him. He had to, there's no way he can say, I did not have any idea that when I asked for my child back, the agency wouldn't point out to the court that I'm no longer a good placement because I was intoxicated to the point that I blacked out. And that argument, how he could say he doesn't have notice, that doesn't make any sense. The court would have to consider that.
Well, clearly the court could have considered it, but what concerns me is that once the father raised that and inquired as to what is the scope of this hearing, and apparently even the court said, I'm not sure that I really have the authority to be able to consider this, and then said, presumably, well, I can consider it, but it will only go to whether or not the stay is lifted.
Right.
Then, without any notice to father, comes up with the order relative to the objections. So where's the notice for that?
I don't believe that, I don't recall, and I don't have the transcript memorized, I don't recall that interaction occurring exactly the way it was presented by Mr. Agarwal. If that is the way it is, I still don't think there was any lack of notice because there were multiple objections pending. They all related to where is this child going to be placed. And even if the court said initially, I'm just going to consider it for purposes of whether or not to lift the stay, which would ultimately result in either child goes back to father or child does not, the court is going to consider this post-dispositional information. Father knew he was there to have the stay, he wanted to have the stay lifted. He knew that he had been intoxicated and that the agency was moving to have custody returned to them. So I don't know what it was he would have done differently. I don't know who he was going to call to show that to dispute the fact that he was intoxicated to the point that he blacked out. That is a relevant matter that he was on notice that they were there about disposition. And it was his own conduct. I don't know where the lack of notice could be. I don't recall.
But the objections weren't limited to that issue. There were objections regarding reasonable efforts, et cetera.
Right.
Was there ever an opportunity for father to be heard on those issues before the court ruled? Or this was the hearing?
I believe this was the hearing, and I would have to go back and look through the docket, honestly. His recitation of the facts is not the way that I recall it, and I had 4 other dependency and neglect cases today, so I don't want to, accidentally, inadvertently state a procedural history incorrectly, but it was my understanding that this was the hearing. It was held while the objections were pending, the dispositional order was made. The issue has to be considered when you're talking about disposition, what happened right after the court's order, and to decide whether or not to lift the stay or to not lift the stay. With regard to the issue of whether or not it's a final appealable order, as I said in brief, I find it perplexing. If his position is it's not a final appealable order, then I don't know why an appeal was filed and he's arguing that it's not a final appealable order. Oh, but by the way, you should still make all these decisions. My reading of the case law is that as long as the main issues have been handled, even if the court has not explicitly ruled on every single objection, that this court does not have to dismiss it. I believe this is a final appealable order. He's taking issue just with whether or not the court specifically addressed if there was a finding of reasonable efforts. Clearly, the court found that there were reasonable efforts at the original disposition when father was given temporary custody, and he knows that, so he tries to argue that when the court no longer agreed to have father have custody, that somehow negated the entire order, including the finding of reasonable efforts, and that's just illogical. The agency was engaging in efforts to have the child reunified with a parent and was going to allow father to have custody, to have at least temporary custody. That was the goal, that was the case plan objectives. And then father, through his own actions, engaged in behavior that was a contraindication for being able to be placed with the child at that time. So there's no merit in the agency's opinion to his first assignment of error. With regard to the second assignment of error, the court knew that there were objections pending. The court knew that father had an issue with reasonable efforts. The court also made a finding of reasonable efforts with regard to the agency engaging in reasonable efforts at that first initial dispositional order, and there's nothing to, again, support his contention that once the denial to lift the stay was made, that somehow negates the finding that the agency engaged in reasonable efforts. Are there any other questions? If not, I would rest on the brief.
Council, you have 3 minutes, 44 seconds remaining.
Thank you, Your Honor. May it please the court. Your Honor, in the Henry MH, this is on page 5, top of my brief. This is what this court held. For a trial court's ruling on a magistrate decision to be final and appealable, the trial court must enter judgment independently of the magistrate and must explicitly overrule or sustain any timely filed objections. If a trial court's order fails to comply with either of these two requirements, then it is not a final appealable order. So that is the language I'm going on, and the state even admits the judge did not in any way address my cross objections. Now again, if the court finds it is, I'll move on. Now for the second assignment of error, the state isn't here saying, well, Father knew he was intoxicated. That is absolutely, it was a big point of dispute in this hearing on lifting on the next day. Caseworker testified, and again, everything she said was hearsay, but we didn't object because there wasn't rules of evidence for, because it was only an interim order. So she was just taking testimony for that purpose. Caseworker testified, well, I was told by these people Father was intoxicated. My client got up there and testified, that's not true, that's false, I was not intoxicated, I knew what I was doing and all that. If it was a hearing on objections, I would have subpoenaed the people that told Tanya Vanderveen, the CSB caseworker. I didn't have any opportunity to cross-examine or confront those witnesses because it wasn't a hearing on the objections. It was only to lift the automatic stay. And if you look at the bottom of page 6 of my brief, I cite explicitly in the transcripts when Ms. Vanderveen starts to testify about these subsequent events, I start objecting and the judge says that she had an obligation to consider this information since Father was only asking for an interim order in order to return the child pending the objections. So even the state is saying, we're here only because you're asking for an interim order and that's what it's going to be considered for, fine. This testimony is coming in for that limited purpose, or I would argue strict rules of evidence are going to apply if you're going to make a dispositional modification. Now I think this, in my third assignment of error, I think the state is conceding that the judge made no finding of reasonable efforts at the adjudicatory hearing, nor made a finding of reasonable efforts when she took the child and placed the child back in the agency's temporary custody. It was a change of disposition. Whether you want to call it an overruling of the disposition or a modification of disposition, she was still required to make a finding of reasonable efforts. Now I've argued she didn't, or there's no finding of it. They're saying, well, you didn't prove any evidence that she didn't. There wasn't reasonable efforts. I can't file a negative. I can't argue that the judge did not do, that there was evidence that she did not do something. If there was reasonable efforts, they have to present what were the finding of reasonable efforts, and then I can challenge that. But to somehow present evidence, based upon all that, Your Honor, there was no reasonable efforts. One, it's not my burden. And two, it's not in the record, so I can't attack the negative implication there. So on that finding, Your Honor, on that argument, Your Honor, I'd ask the court to reverse and remand. Thank you.
Thank you both for your presentations today. The court will take the matter under advisement and issue a written decision which will be mailed to both sides as well as posted on our website and the Ohio Supreme Court website.